Good afternoon and welcome to the latest in our series of webinars covering key OFR related issues. This one focuses on COLPs and COFAs. My name's David Whitney and I'm a relationship manager in the Supervision team at the SRA who've been piloting new forms of supervision. I have with me Tracy Calvert, Jenny Eden and Leslie Horton who will briefly introduce themselves.
Hello, I'm Tracy Calvert. I'm a policy executive in the policy team and I've been involved in drafting parts of the new SRA handbook.
Hello, I'm Jenny Eden and I'm also a policy executive in the SRA policy team and I've also been involved in drafting parts of the new handbook.
My name is Leslie Horton. I work in the authorisation department and I have been assisting in designing the implementation of the authorisation rules.
Enough of introductions, a brief recap of structure. We will co-present a series of slides in connection with compliance officer issues for about 20 to 25 minutes. There will be a couple of polling questions during that time and that will be followed by a question and answer session at the end and you will be able to email or phone questions in. Let me take you to the overview of the presentation. I think this slide gives a quick overview of the main topic areas which we propose to cover today. But before we consider why compliance officers are required, I'd like to hand you over to Tracy who'll give you a quick summary of the key features of OFR which will provide the context for the rest of our presentation. Tracy.
Thank you, David. We are transforming our approach to regulation in the public interest and for the benefit of clients by introducing outcomes-focused regulation, or OFR. This is a regulatory regime that focuses on high-level principles and outcomes that should drive the provision of services for your clients. The changes are reflected not just in the new SRA handbook, but in our approach to authorisation, supervision and enforcement. This will be risk-based, proportionate and targeted, and we want to have a more open and constructive relationship with the firms and individuals we regulate. There will be much more emphasis on risk, with firms being expected to be more proactive in identifying, managing and mitigating risks. This is reflected in the new SRA principles, which include a requirement to run your business in accordance with proper governance and sound financial and risk management principles, and to deal with your regulator in an open, timely and cooperative manner.
Those of you that are more interested in our risk-based approach are invited to attend our risk seminar, which is happening in September this year.
So why are we requiring all firms to have COLPs and COFAs? Well, as far as ABSs are concerned, it's a requirement of the Legal Services Act that all licensed bodies, that's ABSs, must have a head of legal practice and a head of finance and administration. Our authorisation rules are going to require all firms, not just ABSs, to appoint individuals to these roles, but we're going to call them compliance officers rather than heads of, because we feel that this more accurately reflects what's going to be required of them. We believe that requiring such roles will help firms to focus on compliance issues and proper financial management and will provide greater protection for the public, and we believe that those protections should be afforded to clients of all firms, not just ABSs, and there will be important vetting and suitability procedures in order to enhance these protections.
Thank you, Jenny. So in essence, these roles will support risk management and good governance, which are at the heart of OFR. It will be a condition that at all times every firm has a designated compliance officer for legal practice and for finance and administration. We believe that these roles are key to that element of self-regulation that supports our ability to be an OFR regulator. We also believe that effective communication between regulator and firm will allow us to focus our input and for it to be effectively interpreted and implemented within a firm, whilst also allowing us to concentrate on the higher risk firms.
So, how many of you thought about your COLP and COFA? Let's just do a quick poll to see how many of you have done so. If you can just press yes or no, and we'll see the results coming through in a moment.
It's really encouraging to see that already. Most of you who have responded are saying that yes, you feel you are ready for that. At the moment we have around 94% of people feeling confident about the implementation of COLPs and COFAs, and that's really positive to see. Thank you very much. So, turning now to the detail around compliance officers. The requirements for these officers are set out in Rule 8.5 of the Authorisation Rule. The Compliance Officer for Legal Practice, or the COLP, must be a lawyer and must be authorised in one or more reserved legal activity, must be a manager or employee of the firm, would be designated by a firm and approved by the SRA, and must take all reasonable steps to ensure compliance with terms and conditions of authorisation, except for the accounts rules, and other relevant statutory obligations. They are also under a duty to report any material failures to comply. The Compliance Officer for Finance Administration, or COFA, does not need to be a lawyer, and in addition to those matters listed above, must take reasonable steps to ensure compliance against the SRA accounts rules. Compliance officers are not solely responsible for compliance. They will also be looking at matters within a firm, such as risk and the governance structures that that firm employs. I also think it's important to flag up at this point that managers do still retain full responsibility for compliance, and the role of the compliance officer is not a substitute for the firm's and manager's obligations. Moving on now to the approval of compliance officers, we very much want to emphasise the right person in the right role approach. This means there will be two aspects of approval. They are, we will be looking at the seniority and responsibility of the candidate, and also the suitability of that individual to undertake the role. Turning now to the approval then, not only will we be looking at the suitability of the candidate as part of the approval process, we will also be looking at the internal governance structures. For those firms seeking licence status, you will make your compliance officer nominations as part of the general approval process at that stage. Similarly, for recognised bodies, from the 28th of February 2012, you will be asked to nominate your compliance officer when seeking recognised body status. For existing firms, you must designate your compliance officer candidates by the 31st of March 2012. We will be delivering detailed communication programmes about this later on in the year, but what we must emphasise is that firms must be thinking about this now. David?
Yes, thank you, Leslie. I would like to focus in the next couple of slides on some issues which carry on from Leslie's outline of the overall process for approval of compliance. And the issues that I'd like to focus on are some of the factors which the authorisation team are likely to consider when looking at COLP and COFA applications, the issues of seniority, responsibility and time, and to consider how role holders will fit into the existing or a revised structure within the firm. I think the starting point is to say that authorisation have not yet finalised the list of factors which they will consider in looking at approval of COLPs and COFAs, but they intend to publish their decision-making criteria within a few months, and that's likely to coincide with the designation of the SRA as a licensing body for ABSs. It is possible that alongside the decision-making criteria, information will include illustrative case studies of how particular arrangements for COLPs and COFAs might be handled. And I thought it would be helpful to just look at a couple of hypothetical examples which we have come across in the supervision team from work with firms that's ongoing. So, two examples. The first one, a small sub-10 partner firm which uses a self-employed bookkeeper who works for the firm for 2 days a week in order to ensure that its finance and records are in accordance with the Solicitor's Accounts rules. Could he or she be a COFA? Well, it will probably depend on whether they satisfy the definition of employee in the authorisation rules, and that may depend on the particular contractual arrangement. But the key issues here on this case would be the time that that person had available to deal with the responsibilities of the compliance officer. This person would be part-time. We would perhaps be concerned about the level of authority that person had within the firm, and it may be that they would have achieved insufficient buy-in or ownership of the necessary issues within the firm. Looking at a second hypothetical case, a recently retired partner being employed as a consultant to work as a COLP. That wouldn't necessarily be a full-time role, but the thing that they would bring to the arrangement would be authority. If they had worked within the firm for a considerable period, they are likely to get that buy-in that the previous example might lack. We would envisage that that sort of person would report to the partnership board or a risk committee, and their time may be flexible enough to allow them to focus on the key issues. So those are two hypothetical cases. What about issues going on to the next slide, which might be more of interest or more pertinent to larger firms? Some of those are set out on the slide you see. Our key concerns here are that an appointment of a compliance officer actually addresses the requirements we have for this role and is not just a role given in title only. So, for example, if a managing partner were to take on the COLP responsibility, how would he or she make it work alongside their other existing duties? That may involve changing reporting lines so that others with a risk and compliance responsibility would report into the managing partner as COLP, and it may require new arrangements for oversight. The slide suggests a risk committee or perhaps an audit committee. And we would look at how regularly the COLP would report or escalate matters to committees or oversight arrangements. We'd be interested in the terms of reference that operated in that situation, and also the mechanisms the firm used to actually identify risk or to report it onwards. Just going back to the managing partner example, we see good and perhaps less good issues around that. Clearly, the managing partner would have the advantage of seniority, responsibility and authority, which we want a COLP to have, but be under stress and strain in terms of the amount of time they could dedicate. And in that sort of arrangement, it might be necessary to have a delegation of some of the day-to-day responsibilities to other people to work alongside the COLP. So those are just some of the ideas we're hearing about and looking at, and may give an illustration of some of the things that we would look at in an approval process. Let me hand you back to Leslie to deal with suitability.
Thank you, David. In addition to considering the candidate's role in the firm, we will also consider the individual against our suitability test. The suitability test is part of the SRA handbook and replaces the current character and suitability guidelines. I would urge you all to look at the suitability test, which is available online, so you can understand what's coming. The suitability test applies to all compliance officer candidates, even those that are solicitors. The premise of the test is that we need to ensure that any individual maintains the highest level of honesty, integrity and professionalism expected by the public and other stakeholders, and importantly, does not pose a risk to the public or the profession. The suitability test includes more detailed questions about the candidate's history, as well as specific guidance on what our approach will be. Examples of the type of issues we'll be interested are criminal convictions and behaviours, any behaviour exhibiting discrimination, dishonest behaviour for example. We will also be looking at the financial history of that person for evidence of any financial mismanagement, and we may also look at other issues such as directorship disqualification. In addition to the suitability test, we will also be looking at vetting candidates who want to become compliance officers. So what does this mean? Well, vetting is a method of verifying information and will include some background checking against candidates. We are currently in the process of designing that process, and new tools are currently being designed as part of the authorisation design, where decisions are made as a result of issues identified as part of vetting. The results will be disclosed to individuals, and they will have the opportunity to make representations to explain how they are suitable. Tracy.
Thank you, Leslie. We've already talked about larger firms, so what about sole practitioners? All firms will need to have designated a COLP and COFA by March 2012 and to have applied to the SRA to have that designation approved. Your COLP and COFA will need to take up their duties by the 31st of October 2012. This is the same whatever type of firm you are, whether you're a sole practitioner or a larger firm. So now is the time to take stock of your compliance arrangements and to start thinking about whether there is anything you'd like to or need to change. You may well find that you are already fulfilling these roles to some extent. For example, you may already have in place systems for checking conflicts and controlling undertakings. You may already be looking at the risks that your firm faces and how you manage and mitigate these risks. Don't forget that even if you are nominating yourself as the COLP and COFA, you will need to go through the full approval process. If you intend to nominate someone else within the firm, you will want to ensure that they are of sufficient seniority and have sufficient responsibility to fulfil these roles properly. Jenny.
So, now you've heard the detail about these requirements, let's have another quick poll just to ask whether you feel able now to implement the requirements for COLPs and COFAs.
That's pretty encouraging at this stage. 95% to 94% believing that they can fill the role.
Okay, I'd like to move on, now the polling seems to have settled down, to the next aspect that we'd like to talk about, which is supervision and compliance officers. And I think the starting point for that is to look at communications that will take place between the SRA and the compliance officers who are nominated and approved. The type of communication will, to a large extent, depend on the risk assessment that the SRA takes or makes of your firm. Just to recap back to one of the early slides where Tracy was giving the context of COLPs and COFAs, OFR is a form of risk-based regulation, and the key to this new approach is the risk assessment of each of the 10 or 11,000 firms in the profession. By risk assessing, we hope to gauge the potential impact that each firm might have on the SRA's achievement of its regulatory objectives. Those firms that we assess as having a potentially high impact are likely to be supervised using close and continuous forms of supervision. At the moment, we're calling that relationship management. Those firms with a medium impact may be supervised using desk-based supervision, and low-impact firms are likely to have occasional contact, maybe visits or thematic reviews from the SRA. So what does that mean in practice? Well, if you are a low-impact firm, it's unlikely that you will have any immediate contact from the SRA. That doesn't mean that we want compliance officers to sit on their hands. What we are hoping is that you will clearly keep abreast of developments, sign up for communications such as My SRA, and look for risk outlook information that we will disseminate. And also communicate with us if problems occur. Either contact our ethics guidance helpline, or if there are matters to report, as indicated in one or two of the earlier slides, we expect you to contact us. For those firms which have a medium or high impact, it's likely that you will be contacted by us. You will have some communication with one of our supervisory teams, and we hope that that will turn into an interactive and useful form of communication. The COLPs and COFAs will be at the centre of that, and it's important for this process to work that everybody is as proactive as possible. The other point on the slide, examples of the arrangements, I've already touched on one or two of those already, so I don't want to reiterate them, but let me just remind you, it is hoped that we will give some examples, case studies in due course to allow you to think through the arrangements that you have and allow you to test them. I think that's probably all I have to say on that slide. Let me hand you over to Leslie on the steps that you might now take.
Thank you, David. David's already mentioned there about being proactive, so what steps should you take now in preparation? Firstly, I'd ask you to please familiarise yourself with the SRA handbook. As I've said earlier, this is available online now, and having read that, you may wish to review your current risk management and compliance arrangements against the requirements. At this stage, you may also wish to consider who you wish to designate as your compliance officer, and consider that individual in light of the published suitability test. What I would say is that by preparing now, it will make the approval process as hassle-free as possible for both you and your firm. If you have any specific queries whilst preparing for approving of the COLPs and COFAs, you can also contact our professional ethics team, whose details are available online. And finally, I'd just like to take a moment again to talk about timelines. We've mentioned many of these dates previously, but just a quick reminder. For those of you that may be seeking ABS status, you'll be able to fill in an application form from late summer onwards, seeking authorisation. And as part of that process, you'll be nominating your compliance officers. If you're an existing legal disciplinary practice with a non-lawyer management, you can choose to passport early, and those applications can be submitted again from late summer of this year. However, if you do not elect to passport over early, you will still need to nominate your compliance officers by the 31st of March next year. If you're an existing recognised body or a sole practitioner, you must provide details of your prospective compliance officers by the 31st of March 2012 so that their roles can be effective from October next year. And for all those who will be seeking new recognised body status in the early part of next year, from the 28th of February, new applications will include the COLP and COFA nominations, and these will need to be submitted with your applications in readiness for October 2012. So now we've given you a lot of information, and I do thank you for your attention. So now it's your turn to ask us questions.
Leslie, just before we move to that, I would like to say a few closing words and remind you of some other resources which you might find helpful. Those in part appear on the slide. I heartily recommend OFR at a glance. If you go to our, the first page of our website, there's a large chunk of information accessible about COLPs and COFAs and issues that arise from it. The other links are useful too. Watch out for the webinars. I think Leslie mentioned one on risk already this afternoon. And let me also inform you of 3 roadshows that are coming up about OFR if you've been unable to attend any of those so far. One in London on the 6th of September, one in Manchester on the 13th of September, one in Birmingham on the 20th of September. So after that little bit of cross-selling, it only remains for me to thank you for participating in the, at least the presentation part of this afternoon's webinar, and we now look forward to hearing from you with some questions.
That concludes today's presentations, and we are now about to begin our question and answer session. I'd like to remind you that in order for you to claim 1 hour of attendance at an accredited CPD course, we do need you to remain with us until the end of the Q&A session. You can now begin to submit text questions and comments using the box provided on screen. Alternatively, to ask a question or make a comment by telephone, if you've not already dialed in, please dial 0203 159 9716 and type "I want to ask a question by telephone" into the Q&A box and stand by to be introduced by the operator. I'll now hand you back to the presenters.
Right, so we've already had a couple of questions. The first one is, why must COLP be lawyers? Why can't they be individuals specialising in compliance, as is typical in FSA authorised bodies?
Shall I answer that, Jenny? It's a requirement of the Legal Services Act in relation to alternative business structures that the HOLP is a lawyer. Our aim in drafting the handbook and the requirements in the authorisation rules were that the regulatory requirements should be the same for all types of practice that we regulate, and that's why COLP must be lawyers. Another question that we've been asked is, will the nominated COLP and COFA be required to attend courses? Jenny, have you any thoughts on that?
Well, there aren't any specific training requirements set out in the rules. It'll be for the firm to decide what's appropriate for their COLP and COFA, and that's going to depend really on the nature of the firm, the size, the type of work that they do. But firms do need to realise that they have an obligation under outcome 7.6 to require them to train their staff to maintain a level of competence that's appropriate to their work and their level of responsibility. So that will be relevant to the COLP and COFA as well as elemental staff.
Another one, which I think we already touched on in the presentation, was, can a sole practitioner be both a COLP and a COFA? And yes, they can. They can fulfil both roles if they consider they have the necessary skills and experience, and of course if they're approved by the SRA in that way.
Jenny, you may be able to help with this question. Is the SRA able to confirm that the handbook is in its final form? The questioner there says that they understand that the LSB has made further changes to the handbook.
There have, we understand, been some very minor changes which are in the process of being finalised, and the version that's on the website at the moment is a draft and it's clearly marked up as such. And obviously as soon as those changes are confirmed, they will be published on the website.
Is it fair to say, Jenny, from what you're saying, that we might expect that what appears on the website at the moment is perhaps 95% there? Any changes would be, we expect, if any, very minor?
Very minor. I would say probably more like 99.9% as it's going to be. Would you agree?
Yes, no, I think so. I think you can start to plan with quite a lot of confidence that what you're relying on by way of resources is more or less the final version.
Okay. I have a question here. The questioner asks, how will I know what level of risk my firm is assessed at? That is a question we've been asked a great deal, and I'm afraid to say that we will not be publishing what the impact assessment is of any firm for various reasons, really. But what I think you will find is that if you are a medium or high impact firm, as I mentioned in the presentation, it is likely that you will be contacted in the next few months either by a relationship management team or a desk-based team. It is envisaged that firms who are not contacted in that way will be given some form of contact point, but that has not yet been determined.
There's a question here from Michael that I think I'm able to deal with, and that is, when can we send our nominations for COLPs and COFAs, and how do we do this? If you're from an existing firm, Michael, what I would say is that you'll be asked for your nominations from probably January next year, and you'll be able to submit your nominations online through MySRA. Just a quick point on MySRA, you'll be sent your passwords and your secure codes throughout the summer in time for those nominations early in the new year.
Another question, will the SRA publish any further examples of what will amount to material failures that will require reporting by the COLP or COFA? I'm not aware at the moment that further examples are in the pipeline, and that is really a question that will require each firm to consider in their own circumstance. And of course, that to some extent is the way we deal with things at the moment. If a matter is amounts to serious misconduct, a firm must look at the guidelines relating to Rule 2006 in connection with whether it's sufficiently serious to report or not. But if there is a doubt, as I've mentioned earlier, it could be an issue you raise with the ethics guidance, or if you have a point of contact in supervision at the SRA, I would urge you to call them and have a discussion. Some of the firms that we're already dealing with do that and have gained confidence that they can do so without fear of a matter being escalated to some kind of enforcement action if the matter can be reported and resolved in other ways.
Leslie, I'm hoping you can help with this one. Will the COLPs and COFAs require CRB checks?
As I mentioned earlier, we're currently designing the approval process at the moment, and I think we are envisaging that all what we call authorised role holders will have to go through a CRB check. Just for your information there, an authorised role holder includes not only compliance officers but also managers and owners of recognised bodies as well. But like I say, the process is currently under design, and we will be communicating with the profession later on this year to give more details of what will exactly constitute the approval process.
Thank you. And another question that Greg has asked, can a COFA be a COFA at two different firms? Greg's cashier works at two different firms, and at Greg's firm part-time. I think we've touched on this, haven't we, I'm talking about employees being the COFA or the COLP. Your COFA must be an employee of the firm, and we have the definition of employee, but there's nothing to stop somebody being an employee of two firms.
Yes, I think that's correct. I think going back to the hypothetical example I referred to, I think what we may be looking for here is a difference between somebody who might technically comply with some of the requirements and whether or not they are really in a position to have suitable responsibility or authority, not only within one firm but two firms simultaneously. And I think that would a situation like that would be one that we would want to look at quite carefully before approving one or both of those positions.
We've got a question here about will firms with no suitable COLP be closed down? Like I say, the approvals process is currently under design, and what we do, if a nomination was made for a compliance officer and that nomination for whatever reason wasn't approved by the SRA, we would work with the firm in order to identify a suitable COLP or a COFA. It would not simply be a matter of there's no suitable COLP, therefore there'll be a closing down. We would enter into a dialogue with the firm in order to help resolve the issue. So I hope that gives you some comfort there.
Another question, which I think is for Leslie and David, can you reiterate when a firm's status will be confirmed? Will it be on application or will it be available before?
I'm not quite sure what you mean by status there. Perhaps if you're talking about, I know we've talked about risk and whether a firm would be high risk or medium risk, and I think David's already answered that point. I'm not quite sure what other status could mean. David, do you have any views?
And that was exactly the thought that was going through my mind. The only other thing I had in mind was will an applicant be kept appraised of where its application for COLPs and COFAs has got to? Perhaps that is something that the questioner has in mind.
I mean, if that's the case, then I've mentioned my SRA previously, and just to say at this point that you will be able to track the progress of applications generally through my SRA. Somebody has asked a question about how you can log on to SRA, so I'd just like to reiterate again that if you are a part of the regulated community, you will be sent your password and secure code to access my SRA over the summer. They will be with you shortly.
I've got another question here. What are the requirements for a deputy COLP or COFA covering holiday or sickness? Now, I'm not aware of any actual requirements in the handbook for a deputy COLP or COFA, or the fact that the SRA would necessarily recognise people as such, but in terms of sensible day-to-day arrangements, we would obviously look for anybody who has the responsibility of COLP or COFA to have somebody to monitor their roles whilst they were absent from the firm, and to be able to report matters to the SRA as appropriate, or escalate them within the firm to a risk committee or oversight board. I think that the practicalities of the situation is what I'm focusing on there. I don't know whether you've got anything else to add, Leslie?
No, I think that's right. I mean, what we think about in terms of the COLP and the COFA, it's not necessarily a job title as a responsibility, and because it's invested in one person, we would obviously envisage that person taking holiday or being off sick leave. So as long as there are appropriate delegation procedures in place, that's not an issue at all.
Right, and sorry, were you going to say something?
I was just going to refer to another question here, that you referred to the COLP being a solicitor. Can it be a legal executive? Just for clarity on that point, the COLP must be a lawyer. That doesn't necessarily mean a solicitor. And a legal executive could potentially be a COLP if they are a filing. Any other points on that?
No, I know it would be for the firm to decide whether that person had the necessary experience and standing within the firm.
I think I saw a question referring to another similar point, was can a registered foreign lawyer be a COLP?
I think, again, I'd go back to the definition of what a lawyer is. My understanding is that they wouldn't be allowed to be the COLP, but more information about the requirements for compliance officers generally can be found in the authorisation rules.
And on the same theme, another question, can a money laundering reporting officer also take on the role of COLP? Well, yes, if they are a lawyer of England and Wales, but they'll really need to consider whether or not they have the seniority to deal with the role properly, and whether they have the time and the resources, because being a money laundering reporting officer is in itself quite time consuming. So can they also take on the role of COLP and do it sufficiently well, given what other demands they may have on their time? It'd be a matter for the firm to decide.
Another question we've been asked is what is meant by reserved legal activity. This is defined actually in Section 12 of the Legal Services Act, but it's basically those activities which are reserved to solicitors and other lawyers. It's just the same ones really as are reserved at the moment. So that will include the conduct of litigation, rights of audience, reserved instrument activities, probate activities, notarial activities, and the administration of oaths.
We have another question here about timing. When can existing solicitors firms first apply for authorisation of their COLP and COFA? I think I've mentioned that the nomination form will be online from early next year, and as soon as it is available you will be able to make your nominations, but this must be done by the 31st of March next year. The compliance officers' roles will be effective from October, but they must be approved before that date.
Right. Here's another one I think for you, Leslie. If we nominate a practising solicitor as a compliance officer, will that person be automatically accepted by the SRA, or will they be vetted?
Even if the candidate is a solicitor, they will still have to go through the full approval process, which will include vetting and the full suitability test. So that might include, we mentioned earlier about a CRB check, for example. That may happen, but yes, it will still have to go through that full approval process.
Right, and talking of the approval process, we've been asked how long the approval process is.
I'm currently working in the authorisation design team, and I'm currently assisting in the design of that process. We're not able to give any specific timelines yet for how long an approval will be. I think what I will say is with the introduction of online working at the SRA and as applications can be submitted online, we are hoping to make the approval process as streamlined and hassle-free as possible. So although we've got no specific timelines for you now, I think what I would say is please be assured that we're aiming to make that approval process as short as we possibly can.
There's a question here. Are there any forms or written guidance on which specific records officers will need to keep? What immediately goes through my mind in respect to that question is if you look at the authorisation rules, there are guidance notes in relation to, I think it's Part 8 of those rules, which set out the kind of arrangements and systems that we are looking for firms to have in place as part of their authorisation. So that is some form of guidance, but we are not being prescriptive beyond that.
Thank you. One other question we've had, which I think we've touched on, but we'll stress again because it's quite an important point. Can a COLP and COFA role be fulfilled by the same person in a partnership? Well, the answer is yes, if that person is a lawyer of England and Wales, but the firm and that person needs to really think about whether or not they have the time and the resources to do both roles together.
What will happen is that in those circumstances, probably 2 application forms will need to be submitted for, even if you're one individual, for the COLP and the COFA. And what we'd be looking at in those circumstances is that that individual as a whole is able to take on both of those roles. Now, obviously, the less time that an individual would devote to the role, probably the more questions we will be asking for that individual to demonstrate that they can take on both of those roles sufficiently. But we wouldn't rule out the fact that somebody could be both the COLP and the COFA in a firm.
Okay. And with regard to the COFA, we've been asked whether the person needs some sort of certification in accountancy or a number of years practical experience of accounting. And I think it's true to say that we don't have any specific qualification requirements for the COFA, but they will need to have an understanding of the accounts rules so that they can monitor and review and manage risk to compliance. I'm wondering, Leslie, will we be asking any questions about knowledge of accountancy and accountants' rules of a COFA?
What we'll be asking for is we'll be asking for the employment history of those individuals. So although we wouldn't be asking for particular certificates or qualifications, what we would be seeking to do is to gain a picture of that individual as a whole, so to understand if they have any qualifications, what those are, and also what their employment history is.
I had a question here from David. How will you be able to assess suitability as COLP or COFA for someone who intends to start up a new practice in 2012 as sole practitioner?
I think again I'd go back to the point I've just made about it may be a new practice, but we'd want to see what arrangements you're going to have in place for that new practice, and we'd also be looking at maybe the history of that individual. Let's say that you were planning to nominate yourself, David, as the COLP and COFA, and that you are a solicitor with a number of years of practicing experience. We may also take into account, for example, your regulatory history when looking at that. And just as a follow-on question from that, someone's asked, if firms need a COLP and a COFA at all times, what does a firm do if one of those post holders leaves the practice, and how long will it take to get a replacement registered? If there's an unexpected event, that means that somebody's left, a firm can apply for temporary emergency approval of an authorised role holder. So if you come to the FRA as soon as you're able to, usually within 7 days or so, you can seek temporary emergency approval of an individual to be a COLP or a COFA, and then you can submit a substantive application thereafter.
Okay, another question which has come in, which I think is for Leslie and David again, is should we keep a risk register in relation to the practice in general, and what other areas should we consider particular relevance? I think the caller is thinking about client care issues and the like.
Well, let me address the risk register point. As I've indicated, we in relationship management have been undertaking some pilot relationships with firms of all sizes, from sole practitioners to a number of the firms in our pilot have been using risk registers, and they have found it a very helpful way to get a snapshot of the risks which exist to their firms, and it also provides a way of measuring the seriousness and likely impact of those risks, to monitor the steps that can be taken to mitigate the risks, and to provide an action plan going forward. Looking at firms that have had risk registers in place for a period of time and comparing how the registers change over that period is very useful for a supervisor to get a very quick view of what's going on. Some firms also find it helpful as a way of informing their risk committees or audit committees of how they are handling risk. So I think it is a useful tool, but it is certainly not prescriptive. I'm afraid, could you remind me of the second part, or have I covered that already?
I think you've covered that. I believe we have a caller on the line. Good afternoon. Hello, do we have a caller? It's Mr. Andrew Crew.
Yes, hello. Question relating to the detail of the COLP's role. Under the authorisation rules, I think I'm right in saying that a COLP must take all reasonable steps to ensure compliance with any statutory obligations of the body in relation to it carrying on its authorised activities. Read literally, that is a very wide obligation indeed. How far is that actually intended to mean any statutory obligation in relation to our work as solicitors? Because, you know, as I say, on a literal basis, that would seem to me to include all employment law, all health and safety law, everything else that as good solicitors we need to make sure we comply with.
I think you raise a couple of interesting points there. I think what I'd say is that again, we tend not to be prescriptive in our approach here, but I think you'll find that the sort of the key notifications and information requirements are those really that are in the authorisation rules, the practice framework rules, the practicing regulations, the code of conduct, and the SRA accounts rules. I also suggest that actually when we're talking about statutory requirements, actually we're also talking about the requirements of the Legal Services Act, particularly in respect of alternative business structures. I think what I would get across here, and I think David might agree with this, is we are looking at outcomes-focused regulation. What we're not seeking to do is we're not seeking to trip firms up. We're not intending to set people impossible tasks. What we're looking for is a firm that is managing its risk, managing its compliance, and providing the best possible service it's able to for its clients. David?
Yeah, Leslie, I think you make a good point, and I don't know if Andrew's still on the line, or there was a bit of interference. I don't know whether you're still there, Andrew, but this is risk-based regulation, and I think we would want to ensure that we understood exactly what risk any potential statutory or regulatory breach might cause, either to the firm or to our regulatory objectives. Our approach is that we want to be targeted and proportionate. I remind you of the things we've already discussed, which are that we're looking for material breaches to be reported to us, and if you are in any doubt, it may be something for discussion, as I mentioned earlier, with either ethics guidance, or if you have a direct contact at the SRA in the supervision team, give them a call. I hope that covers that off.
Thank you.
Yeah, one of the questions we've received is, I understand we need to change our headed paper and website to read authorised and regulated by the SRA. Can we make this change now? I don't think there's any reason why you shouldn't be authorised by the SRA. Isn't referring to being authorised as a licensed body or recognised body. It's more the fact that you're authorised to carry out reserve legal activities and other activities. So I think if you did make that change, you wouldn't really be doing anything wrong. I don't know if you agree with that, Leslie.
I think that's absolutely right. I think just a point actually, about terminology. When you look at the handbook and the authorisation rules, we refer to authorised bodies, and that means all bodies that are authorised by the SRA. Now underneath that there are two categories effectively. They're recognised bodies, and they might refer to, if you like, traditional so-called law firms, and also licensed bodies, which will be alternative business structures. So I don't want anyone to be confused about terminology, but I would absolutely agree with what Jenny said there.
I don't know whether this is one that's already been covered off, but under the new suitability test, does financial probity include obtaining personal tax records and history, and if so, over what period of time?
We don't have any plans to interrogate people's personal tax records. Again, I would refer you to the suitability test, which is available online. It's currently at page 394 of the SRA handbook, and that will give you an idea of the types of issues we will look at. But again, I don't think personal tax records is particularly one of those that we will interrogate.
A question that we've had in is, how many firms do we think will have a relationship manager? Can we assess that with any...
Well, I can't give absolute full clarity on that. The relationship pilot, which is looking at whether or not this form of close and continuous supervision can be effective, is due to finish this month, July 2011, and we will review how successful the pilot has been. I think it is anticipated that some form of relationship management will be used as part of the overall supervisory approach, and we have looked at the possible resource implications. We're still looking at those. I think it's fair to say that at least 50 to 100 firms may have some form of relationship management at the outset. This is obviously something which will require a review, and I can't really say anything more than that as an indication.
Okay. A couple of similar questions here, so I'll ask you both of them. Although all firms are different, will you be able to provide any sort of template for risk registers or other documentation? And can we see an example of a risk register on the SRA website?
We certainly, in one of the webinars, gave a very simplistic set of headings for a possible way of approaching a risk register. We don't want to be prescriptive because actually I think the important thing is to find mechanisms which work within each firm. We have, on the relationship management pilot, discussed registers which firms have produced and made some observations, including passing on confidential, without breaching confidentiality, passing on approaches that other firms have used that we think may be of help. So I wouldn't say that we can't give some steers, but I think we're reluctant to go too far down that route. If the person asking the question wants to, they're very welcome to get in touch with me to take that conversation a little further.
Still on the subject of risk, David, being asked, would the SRA licence an ABS that's being assessed as medium or high risk?
I think one of the confusions which occurs around the risk assessment is the difference between the concept of risk and impact. And I haven't really had time to go into that in a great deal of detail, but if you have the chance to go to a roadshow and go to the risk workshop, that may make it a little clear. What we're talking about in terms of the risk assessment is if something went wrong at a firm, what impact would that have? If you were a large firm, would it mean that it had a significant amount of intervention requirement put on our budget, or perhaps a large call on the compensation fund? So we have seen a number of firms which are extremely well run, are very risk aware, perhaps use risk registers, already know who their COLPs are going to be, and have an extremely good compliance record, but are still going to be assessed as high impact firms because if something goes wrong, however unlikely, it would cause a difficulty for the SRA achieving its regulatory objectives. So I hope that answers that point. Impact and risk are different. I think we've just got time for one more question.
Okay, go on. How could a legal accounts executive be a COLP? They are a fellow of the Institute of Legal Executives in Accounts. I'm not sure that if they've got a limited membership. Is there a type of membership just relating to accounts?
Well, I think if they are a fellow of ILEX, they will be a lawyer of England and Wales, so they fit the bill for being a COLP, and then I think we'd just ask the firm to think about the suitability of that person given whatever experience they have on a day-to-day basis for being the head of compliance, the compliance officer for legal practice. Would you agree with that?
Yeah, I think that's absolutely right. As long as they're a FILEX, I think that's right, they are a lawyer. I'm not sure about the second part, if they're just a FILEX and accounts, I don't know that, and you might want to speak to your own regulatory body just to clarify that situation. Just one final point, we've had several questions about can COLPs be freelancers, can we set up our own consultancy firm for compliance officers. Just to be absolutely clear, a compliance officer needs to be either an employee or a manager of the firm in which they're a compliance officer for. So just to give you some idea about what the requirements are there.
Just one thought, we have had a very large volume of questions today on these issues. Clearly we've not been able to deal with all of them. We tried to get through a large number. At least on one previous occasion in a webinar, we tried to capture and distill some of the questions that had not been addressed. And we will look at doing that after this event in order to perhaps cover anything that has not been dealt with before. But as regards how long that will take and where it will appear, I think you'll have to watch this space. That concludes our presentation and questions and answers for today. So thank you very much indeed for participating. Perhaps look forward to hearing from you or working with you in the future.
Thank you.
Thank you.
Bye.